Good afternoon, everyone. Thank you for being here. My name is Robin Hansen, and I'm pleased to welcome you to the Law Foundation of Saskatchewan H. Robert Arscott Lecture. As we gather here today, we acknowledge we're on Treaty 6 territory and the homeland of the Métis. We pay our respect to the First Nation and Métis ancestors of this place and reaffirm our relationship with one another. I'd like to begin by thanking McKercher LLP for sponsoring our lecture series, and I'll ask Brett Kavanagh to say a few words on behalf of the firm.
Thanks and good afternoon. I'm a partner in our Saskatoon office in our education practice group. McKercher is very proud of the relationship with the College of Law and the continued opportunity to play our part to provide timely and interesting lectures through this series. Personally, I'm both an alumni and have had the honor to work for the university for over a decade now. On today's topic, my spouse is a teacher at a community school here in Saskatoon, and her main focus in the last 2 years was to become a trauma-informed teacher. And by comparing to her, I've seen how desperately our industry needs this type of training, and I really look forward to Dr. Smyth's lecture today.
Thank you very much, Brett. The Law Foundation of Saskatchewan H. Robert Arscott Chair was established in 1989 under an agreement between the Law Foundation of Saskatchewan and the University of Saskatchewan. The chair was renamed the Law Foundation of Saskatchewan H. Robert Arscott Chair in 2014 in honor of H. Robert Bob Arscott, FCA, who served as Secretary of the Law Foundation of Saskatchewan from 1973 until his retirement in 2013. The wide terms of reference for this chair accommodates appointments in any area of law or in law and policy. Incumbents are accomplished legal scholars or other outstanding persons with a background in law and a demonstrated interest in scholarly investigation and practice relating to issues in law and policy. Although the holder of the chair has teaching duties, he or she will also engage in research or other scholarly activities, such as conferences and special seminars related to the chair. Professor Gemma Smyth is an associate professor and externship director at the Faculty of Law, University of Windsor, on the territories of the Three Fires Confederacy. Professor Smyth has held various positions at the faculty, including Associate Dean Academic, Academic Clinic Director, and Director of University of Windsor Mediation Services. She teaches, researches, and writes in areas related to clinical law, dispute resolution, lawyering skills, and legal education. She's the co-author of the first text on clinical legal education in Canada with Professors Sarah Buehler and Sarah Marsden. She's past president of the Association for Canadian Clinical Legal Education, a national collaborative working on issues related to clinical and experiential legal education in Canada. In January, we welcome Professor Smyth to the College of Law as our Law Foundation of Saskatchewan H. Robert Arscott Chair. Please join me in welcoming Professor Gemma Smyth.
Thanks so much, everyone. Just get my notes. Okay, is the volume okay? Great. Thank you so much, Professor Hansen, and thanks, Brett, very much for the kind introduction, and to McKercher, of course, for sponsoring this lecture series. I've attended several of them while here and have been thoroughly impressed with the quality and breadth and depth of the speakers. And I appreciate that too. I'm not sure if there are folks online, but if there are, welcome. Thank you for coming online, and thank you for being here in person as well. What a welcome I have received here. I just wanted to take this opportunity to thank everyone. I feel like, yes, I've made kind of professional connections and been really revitalized in that way, but I've also made friends, which I was not expecting, but am so, so grateful for. This community is something special, and this chair is something very special. I think, as far as I know, and I've done work at many law schools across Canada, I think this is a unique position, this kind of short piloting in to share ideas, cross-pollinate, and it's been very, very effective, and really, I'm so grateful. I don't know if Katie is here, but Katie Richard has been an incredible organizer. Thank you very much, Katie, for your work. The Speakers Committee, of course, to Dean Martin Phillipson. I did have a picture of Martin playing drums at the law students' annual meeting. I declined to put it up here, but suffice it to say he could have had another career in the music industry. So the chair, as you know, and Professor Hansen alluded to, is named in honor of the late H. Robert Arscott. So I've kind of asked around to try to find out who he was and what he did and his connection to the college. So of course I heard about some of the things that Professor Hansen mentioned about his career as an accountant, his work with the Law Foundation. But the most common threads in these stories were about his generosity of spirit, his kindness, his commitment to the public interest, and wow, what a legacy to leave to this community. And beautiful that that's what people remember him for, as well as his professional accomplishments. And I have to also take this opportunity to thank my spouse, who has been a total rock star and taken care of our children. It's March break in Ontario, so he's really taking one for the team of Smyth Vasey. So thank you to him. It's incredible to be in a partnership. I'm very fortunate where I can be here for a significant period of time. So I'm going to talk for about 35 to 40 minutes, and then I'm going to leave some time for questions or comments afterward, and I very much see this as a conversation. I'm going to, I hope today, talk about a topic that opens up, I think, a doorway to thinking about the human experience, so lawyers can work more effectively with their clients and situate themselves within an increasingly difficult social and legal environment. And you know that the academic way is sometimes to take a really kind of promising topic, tear it to shreds, and as a sort of intellectual exercise. That is really not what I want to do today. What I'd like to do is offer ideas, collaborations, ways of thinking about this subject in a way that I hope is collaborative rather than sort of tearing people down. And I think that comes partly from the discipline. So I've spent my career mostly in clinical legal education. Most of you probably know what that is, but if you don't, it's an environment where a clinic that is affiliated in some way with a law school places students under high-quality supervision, sometimes with lawyers, sometimes with lawyers and social workers. I see the director of the Saskatchewan Legal Clinic that welcomes students, Chantel Johnson, is here, so she can tell you all about that, I'm sure, better than I can. And in that practice, I've had the real great fortune of seeing students in some of their earliest days working with clients. And I'm sure everyone, who's been practicing remembers those days, which can be really challenging in this direct client service lawyering context. So clients in clinics typically are experiencing low income. That's the kind of characteristic that they share. And there are typically other types of marginalization in operation as well. And so this has really impacted how I think about law education and my own kind of research. There's an American clinician, Robert Condlin, who talked about this kind of different orientation regarding curriculum in one way. So he wrote, historically, legal education has been about the study of law, its content, nature, and effects, the interests it serves, the extent to which it embodies and effectuates the principles and policies of our societal commitments. The principal goal has always been intellectual understanding, and the skills directly implicated have been those of reasoning and research. Clinical legal instruction, on the other hand, has generally approached the task of reform from the opposite direction. It has been more of a bottom-up than top-down reform. And this has made it somewhat of an ugly duckling in the law school world. But just as the story of the ugly duckling, I think that this bottom-up approach is actually quite beautiful and adds significant, meaningful insight that can transform our way of teaching and practicing. So in my mind anyway, bottom-up means centering people and community rather than centering the law. And in doing so, I think clinicians add really important voice to legal systems and law reform, specifically because of their insights into the operation of law and policy in people's lives. So particularly for lawyers working directly with clients who have experienced harm, trauma-informed lawyering has been an accessible, concrete way for lawyers to understand and begin to address the real problems they see in working with clients and justice systems. But I have heard and take very seriously critiques from women, especially Indigenous women, that this concept can also do great harm. Feminists have long argued for a more systemic way of approaching trauma that acknowledges the violent systems surrounding women, particularly Indigenous, Black, and racialized women. So today I'm going to explore both aspects of this complicated question and propose a kind of set of ideas that I hope might frame trauma and violence-informed lawyering. And in doing so, I went back and read kind of older clinical literature in Canada and reread the work of my late colleague, Professor Rose Voivodich, who is one of the mothers of clinical legal education in Canada, a really amazing person, the first clinic lawyer I worked with, a mentor in whose job I eventually stepped into. And in one of her papers, she argued for this ecological view of practice that I think, alongside understanding structural violence, can provide an individual and systemic way of approaching trauma-informed lawyering. But before I do this, I have to acknowledge the bitter irony of talking about this topic on land that has benefited my family to the detriment of Indigenous peoples here. My mother's family immigrated to Canada from a German city in Russia with the promise of a so-called land grant in North Battleford on Treaty 6 territory and the homeland of the Métis people. Shortly afterward, they left for Ontario, frankly unable to farm the land. I've kind of stuck around, and my family has stuck around that area. And that is, as Robin noted, the land of the Three Fires Confederacy, the Odawa, Ojibwa, and Potawatomi peoples. And my family have been uninvited guests on both territories. And I also want to acknowledge that much of my learning in this area has been refined and supported thanks to women. Yes, Professor Voivodich, and also Indigenous women who have really helped me reframe ideas around relationships, trauma, and violence. So I want to specifically thank Professor Valerie Wabus, Professor Patricia Barkaskis, and Chantal Johnson, who have patiently, with love and a lot of humor, supported and challenged this work. And frankly, it's the type of work that you need humor in order to support yourself and your community. I'll also give you a content forecast. I'll be mentioning suicide, racism, homophobia, sexual violence, residential schools, the Holocaust, slavery, and other forms of abuse. I purposely omitted any intimate or detailed descriptions of any of these, but they will be mentioned. And I say that simply to give you some kind of mental and emotional space and the option to choose the degree to which you wish to engage today. So trauma talk is everywhere, and Brett, your comments at the beginning regarding education, I think were quite prescient. So sorry, this is not readable by a screen reader for anyone who is using a screen reader. So there you'll see a whole bunch of headlines and studies regarding various approaches to trauma, and I'll make the slides available afterward. Trauma-informed approaches have long been taken up by social workers and psychologists, of course, and more recently it has been taken up in education, journalism, medicine, policing. massage therapy, and yes, tattooing. So I know this term is kind of so ubiquitous that it holds a sort of danger of becoming meaningless. But I also think it speaks to the need for a language of care when working with people in intimate, and in the case of tattooing, physically painful contexts. And trauma talk is compelling. And I think in some ways it's fascinating for lawyers because the field, especially recently, hasn't really, I think, been situated in theoretical orientations of the job of lawyering in direct client service or human contexts, frankly. And I think, any of us who have spent time with lawyers or being a lawyer, I think they're really struggling with how to understand their role in working with people who've experienced harm. Lawyers want to work better with their clients and have experienced frustration and sorrow about how difficult this can be. I wanted to highlight this with some quotes from a study by Dr. Nathalie Cadieux. Most of you have probably heard about it by now. And I've selected 3 quotes. First, I think the issue in criminal law has mostly to do with vicarious trauma and PTSD. You see things which are just far beyond the ken of a normal 9-to-5 job. Although I don't know what normal means, but anyway. Okay, conduct which knocks off kilter one's sense of right and wrong, good and evil. It's like living in a Cormac McCarthy novel. That's dystopian. Knowing one person who has died of suicide arising from PTSD, knowing that the deceased was strikingly like the rest of us, tells us we are all vulnerable to this illness. I practice family and child protection law, and both my work and my life would be better if I could have direct support from trained professionals about the very emotionally distressing work I do. Without that piece, I find lawyers are very limited in our ability to access mental health resources because our counselors do not understand our work and we cannot explain it. And this part blew me away because there's this fascinating quote by Bessel van der Kolk, where he talks about all trauma as being pre-verbal. This is especially true when lawyers come to the profession with experiences of violence, trauma, mental health, and substance issues. Vicarious trauma really affects us. And lastly, the entire study is rife with these sorts of quotes, so I've picked 3. The problem arises when we must work with unhealthy people, victims of abuse, people with extremely difficult problems, due in part to their own upbringing and life circumstance. We want to help these people and identify them with them as a result of that, but it is very hard on us when things don't always go their way. I love my work, but it is killing me slowly. And so I want to take these voices very seriously before diving into critique, because I do believe trauma-informed lawyering is a window, a concrete way to think about human beings and lawyers themselves who have experienced harm. It is a way to grab onto a window of understanding human behavior, a way for lawyers to think about their own mental health and secondary trauma, burnout, and compassion fatigue. And it gives us a language to talk about how the profession can be extremely challenging. So it's opened up a discussion, I think, about a really important discussion, especially in areas related to criminal law, family law, child protection or family services, immigration and refugee law, clinic law, and the law of evidence, to name a few. So many of you will have already kind of had some exposure to this, and I don't want to unduly, sorry, I'm just going to take a drink of water. I don't want to unduly belabor this point. But I'll give you kind of a sense, I guess, of how trauma talk is showing up in the research and practice recently. So in criminal law, that's the most obvious, of course, and probably well researched and documented. Indeed, Professor Elaine Craig at Dalhousie just this morning wrote an op-ed about rape myths and sexual violence trials that continue today. So there's a very, I think, well-documented evidence around the re-traumatizing nature of sexual violence trials, and we've, I think, lots of people are working on sexual violence specifically. How can class action settlement processes act to re-traumatize survivors, for example, through their evidentiary requirements? My colleague, Professor Valerie Wabouth, wrote about the Indian Residential School Settlement Agreement in this regard. Her thesis is available online. In immigration and refugee law, there's a reliance on memory-based evidence in refugee hearings, and we know that that's exactly the type of evidence that's compromised for folks who have experienced trauma. For professional responsibility, there's some really interesting work connecting professional responsibility and secondary traumatic stress, drawing connections between kind of unethical behaviors and those realities for lawyers. In environmental law, there's really beautiful work on earth-centered trauma. And again, work in restorative justice and transformative justice communities regarding whether restorative approaches can address trauma due to its kind of more flexible approach to narrative, process, evidence, and so on. So these are, that was a super fast kind of overview of some of the ways people are kind of engaging with trauma talk and trauma research. But there's much more, honestly. Right now I know of a couple of books that are being published. People are really digging into this in all sorts of areas of law. Now, I know this is somewhat belated, but I'm going to back up to a definition, or a couple of definitions, because herein actually lies part of the problem. It's really tricky to define, and anyone who writes in this area says this, because its meanings really vary widely depending on the disciplinary context and the worldview. And it has different meanings if we frame it individually or structurally. So we can frame it as an individual violent harm, like sexual violence, a car accident, hurricanes, environmental disasters. And we can think about it as community-wide or structural harm, residential schools, slavery, the Holocaust. And it can be complex with different traumas kind of overlapping to create a complicated picture. And it is also insidious, so gradual, constant exposure to racism, homophobia, poverty, and so on. So in law, I think it's fair to say, with some exception, that the dominant way trauma is being talked about is this bio-neurosocial approach. So authors frame their understanding of trauma as having social impacts influenced by the operation of the brain. And so this impacts so many things, like a witness's ability to recall what her assaulter looked like, a refugee claimant who can't remember what year they fled their home country, a client forgetting or changing critical elements of their narrative upon being examined directly or in cross-examination, et cetera. I've chosen two definitions here. The first is just widely cited, and this is a lawyer psychologist research team from Western and U of T regarding trauma-informed approaches to restorative justice. A traumatic event is one which is so overwhelming it diminishes a person's capacity to cope. It elicits intense feelings of fear, terror, helplessness, hopelessness, and despair, often subjectively experienced as a threat to the person's survival. They are not necessarily violent, but always entail the violation of a person's sense of self and security. And this definition from the late Professor Bonnie Burstow adds some nuance to this idea. Trauma is not a disorder, but a reaction to a kind of wound, and we know that the word trauma comes from the Greek word wound, a reaction to a profoundly injurious events and situations in the real world, and indeed to a world in which people are routinely wounded. Although traditionally applied to individuals, it can apply with certain alterations to communities, nations, and the world itself. There is a physicality to trauma. It befalls embodied individuals. And even when there's no explicit assault on the body, people become alienated from their bodies in some respect. Correspondingly, in traumatized communities, it is as if the tissues of the community had been torn asunder. So you'll notice in both of these definitions that the authors don't frame trauma as a diagnosis or a disorder, but a response to a set of external circumstances, and I think we sometimes confuse those two things. Now let's talk about specifically trauma-informed lawyering or advocacy, which I've done what I hope was a good lit review. and gathered kind of a whole bunch of different definitions and aspects that I think are slowly changing over time. So I've listed some characteristics here from the most commonly cited to less commonly cited. The ability to identify what is trauma, having an awareness of trauma, the ability to adjust the lawyer-client relationship accordingly, adapting the litigation and advocacy strategies, preventing vicarious or secondary trauma for the lawyer, focusing on strengths rather than deficits, emphasis on choice, collaboration, and care, and emphasizing safety, including cultural safety. So as we embark on this way of thinking, lawyers, judges, academics, and researchers are raising questions about how trauma talk is framed and practiced. I'm going to outline some of these concerns for three groups: clients, law students, and lawyers. And of course, this is highly relevant for judges and hearing officers as well, but just for the sake of time and clarity, I've omitted them. And in doing this, I really want to emphasize again, I do not want to in any way disparage the work other people are doing, but rather invite ideas into a conversation. So let's start with clients. Clients don't come to you and say, I'm traumatized and here are the reasons why. We know that. It's a professional label that lawyers or social workers or psychologists, whatever the case may be, apply. And it can be another professionalized and Western way of talking about harm. The brilliant Renee Linklater wrote, from a health perspective, as a direct result of colonization, the vast majority of Indigenous people have lived or are living in trauma. In most cases, it is multi-generational and is relentlessly being reproduced and reinvented in various forms. Those seeking help are often confronted with more alienation and traumatization. Culturally influenced Indigenous behavior is often misinterpreted by Western-oriented clinicians as evidence of psychopathology. For the most part, Indigenous trauma has been largely diagnosed through non-Indigenous theories. Western frameworks of psychiatry and psychology have medicalized the experiences of Indigenous peoples, applying diagnoses such as post-traumatic stress disorder, further pathologizing their trauma. Using trauma terminology implies that the individual is responsible for the response rather than the broader systematic force caused by the state's abuse of power. So this individual conception of trauma can make people seem like, or make it seem like a deviant characteristic, I suppose, of a person rather than a feature of how a settler colonial society functions. And it can also act to paper over sources of trauma. So think of a client who successfully appeals denial of a social benefit. They might work with a lawyer who is trauma-informed and uses a kind of do no harm approach, but the client ultimately goes and still continues living on an income that does not allow them to live with dignity. Communities that are over-policed might have a great lawyer who, again, successfully defends clients living in that community, but it doesn't address over-policing. So in some of these circumstances, lawyers can function to kind of reduce harm for clients, which is a very valid and important role. And it also has implications to how we spend our time and resources and how we approach advocacy. And I'll just jump to this, what I think can happen for clients. So people who are traumatized can begin to be juxtapose themselves with so-called normal people. So Professor Burstow wrote, a case could be made that the highly traumatized person actually sees the world more accurately than the less traumatized. And I want to now turn to law students, where I spend most of my time. So trauma-informed approaches to law tend to be quite different to how legal problems are framed in other courses. The client doesn't usually play a central role, at least in an embodied way, in much of the curriculum. So sometimes when we jump to trauma without situating it in this kind of wider scope of human experience, I think it can be a bit challenging and confusing for students. And on the other hand, we don't really talk that much, with some really important and notable exceptions, about structural violence. And so I think students sometimes struggle with that as well. I wrote a paper with Dr. Dusty Johnstone and Professor Jill Rogan, and we found that exposure to trauma-informed education led to significant shifts in students' assumptions and approaches with clients in a helpful way, but it also raised some questions. So some students tended to talk about trauma as a diagnosis, and so we had to be really careful because that's not the lawyer's job, first of all. We also wanted to encourage them to be client-centered, of course. And then a few students also reported a sense of helplessness or hopelessness. For example, if the entire adversarial system relies on memory, for example, or capital T truth, and a person who has experienced trauma has to give evidence in this way, what's the point? And they get very kind of upset about this, which can be a good learning experience, but I think it has to be really carefully supported. And Professor Vojvodich wrote, law students require an orientation that conveys real knowledge about the clients themselves, their relationships to the community in which they live, to the community and social service network in which the clinic is located, and potential avenues for justice. And if we're not including that as part of the kind of trauma-informed approach, I think there are those risks of individualization and medicalization. Now, some considerations for lawyers. There is a definitional problem that I referred to earlier. What is described as traumatic can be confusing and a bit opaque. Sarah Willen wrote, physiological, psychiatric, and popular conceptions of trauma are frequently and confusingly conflated. An increasingly broad array of events are now characterized as potentially traumatizing. If such disparate experiences as physical violence, verbal harassment, and vicarious exposure to others' negative experiences are all equally capable of being traumatic, is it not reasonable to wonder whether the concept of trauma itself might be in danger of losing its capacity to facilitate understanding of the dynamics and lived experience of human suffering? And I think for lawyers, this definitional landscape can also be really quite challenging. So for criminal lawyers, I've talked with some of them, should they rely on a DSM-5 definition of trauma when framing their case? What does that mean and how the client's going to be interviewed? What evidence has to be adduced? How will she be cross-examined? What expert evidence is required to support a diagnosis of PTSD? How will judges understand and interpret this evidence? And how will the lawyer support themselves in this process? I've also done quite a lot of work with legal aid lawyers who take trauma-informed approaches very seriously. But I worry that without meaningful funding for their work, without refocusing how legal aid services are evaluated, it can lead to further stress and magnify problems with underfunding. A kind of lack of systems approach to trauma and violence can put a lot of pressure on lawyers and kind of put the onus on them rather than focusing on kind of some more supportive structures that could be put in place to work more meaningfully with clients. And I struggle with this next piece, this strengths-based approach. So what does this mean in a colonial system that are deeply embedded and married to deficit models? There are absolutely important things that can be done in an interview to reduce harm and to focus on individual and community strengths. I've seen lawyers do it in really quite beautiful ways. But ultimately, if a client is faced with a situation where they have to talk about how bad is it, and from a remedies perspective, there might be some concern if it's not bad enough, I think that's really challenging for lawyers. So I'm going to talk about a model. I'm just going to throw it out. I've obviously spent quite a lot of time thinking about it, but I also this is the first time I'm kind of articulating it for you, or to anyone, actually. So I wanted to propose this in how we frame this really important work. So again, this ecological view was first introduced to me by Professor Vojvodich in my earliest days at Legal Assistance of Windsor, which is a legal aid government-funded legal clinic with social work and law students and social workers and lawyers working on kind of clinic law-related cases. The theoretical heritage of law favors the assessment of the legal problem and the preservation and advancements of the rights, liberties, and property of the client. Lawyers do not necessarily view themselves as public servants. This distinction is manifest in the contrast between the ecological systems theory approach, which takes all aspects of a client's circumstances, including the operation of non-legal concerns and interests, into account in problem solving, and the traditional lawyer's individualistic concentration of effort upon the client's rights, which dominate the legal issues of the case. So I did a bit more investigation here, and I think this idea is inspired by the work of Urie Bronfenbrenner, who used this idea in understanding child development. So I'm going to overlay his ideas with both a focus on relationship and structural violence in a way that I hope will get us to a place of trauma and violence-informed lawyering. I want to also just take one moment to make a quick note that there is some discussion in the literature about the extent to which parts of this were adopted from Maori pedagogies, and this is still used in all kinds of diverse approaches to pedagogy, including in with equity-deserving groups. So I just wanted to put that as a kind of important footnote in the literature. Okay, so what is this ecological model? It's certainly used in other disciplines and has been the subject of critique. It's been used in individual and systemic contexts. And I'm sorry about this. It's also, again, not readable by a screen reader, but I am going to describe it in a way that I hope makes sense. So Bronfenbrenner had this critique about how research was being done in psychology. So this idea that mom does X and Y happens versus control group, stranger does X and Z happens. And he thought, I think that this was a bit ridiculous because it takes the child out of their environment where they're embedded and they live, and it takes away all the kind of other cultural and important aspects of their development. So he situated child development in this ecological view, which understands a person as existing in a multi-layered environment where they are acted upon and they are also actors in their lives and communities. So he describes a bunch of nested systems here. And this graph, by the way, is taken from the much better artistic work of Christer Oland and Klaes Dahlqvist from Christiandad University. Sorry for my accent, terrible. Okay, so in the center is a person, let's say, with their own unique characteristics, talents, traits. Around them, a microsystem of the immediate people or institutions in their lives. So that's their immediate family members, their school, colleagues, friends, etc. Basically things that have direct impact on a person, and they're bidirectional, meaning the research that I talked about was unidirectional. This means that the person is an actor, that they have agency, that they're involved in influencing these systems, which will be important when we talk about lawyers in a couple of minutes. The exosystem might be people or institutions important in a person's life, but a bit more distant and perhaps less controllable. It might be the structure of the courts, social services, what is available at the grocery store, so on. And this mesosystem is basically the interactions between the components of the microsystem that are also influenced by the exosystem. So let's say we have a woman renting an apartment. She's in a relationship with a great deal of interpersonal violence. Her spouse, children, and landlord might be in her microsystem, depending, and because of issues related to family violence, there's some damage to the apartment, complaints from the neighbors. She might be at risk of being evicted, and so the eviction might bring them in contact with family services, so child protection workers become involved. She might be eligible for legal aid, depending on the income cutoff and her assets and so on. And then part of that microsystem might bring in the lawyer. And here, the client is exerting influence, but the lawyer begins exerting influence, and sometimes a great deal of influence on all elements of those systems. And I hope, when I present this to students, I hope that it starts situating the lawyer as having ability to influence the individual case, of course, and the individual client, but also the systems in which the client is operating. So there's great, really interesting research on kind of social movement lawyering, demonstrating that even simply CCing a lawyer on a request equals better action or more response from someone on the other side, whether it's a government actor or a lawyer on the other side or whatever. So there's a great deal of power, and we'll get to that later. So going back to the woman who's now become a client, let's say, there's a complex interaction in micro and exo systems. Professor Patrick gave a talk in my class last week where this really hit home for me when she talks about the interactions between family service provision, the family courts, the role of children in all of this. To me, this really struck home when you were talking about this model and who is left out of this model as well, as you talk about so eloquently. So this macro system, there are attitudes, ideologies, racism, capitalism, culture, gender discrimination. So for our client, she might be existing in a colonial capitalist context with individualistic views, and she might feel a great deal of pressure to be in a family structure with a mother and a father with little outside involvement, and that her failure to maintain this is her fault. We see this all the time working with women. And it also, I think, helps explain why she might be interested in certain legal outcomes and not others. So in this model, underlaying all of this is the chronos system, time, slower changes that kind of occur, and sometimes we don't even notice it over our lifetime. So these influences can shift and can be mapped differently depending on context. Some are more fixed than others. How can this approach be helpful for lawyers? Why did Professor Vojvodich think this was important for lawyers? I think it can help us think about how human experience is mediated and influenced by all sorts of factors, and many of them never show up in the interview room. It situates clients in complex environments where law and legal systems are one of many overlapping factors. It frames the client as an actor in these systems who is exerting influence on her environment while also being acted upon. It can help us, I hope, think creatively and widely about law reform and legal interventions. It situates the lawyer in relationship to individuals and institutions and acknowledges that the lawyer themselves is impacted by the system along with impacting these systems. So that, I hope, relates to the kind of really powerful quotes from lawyers earlier, where there is something that we're not, I think, dealing with in the interaction of the work and the systems on lawyers themselves and the secondary trauma and compassion fatigue that lawyers are experiencing. I think it has important kind of interdisciplinary connotations. And Professor Vojvodich connected this view to what she thought were particular missing skills for lawyers, including collaboration with both colleagues, the client, self-assessment and understanding impact of behavior on others, good communication skills, understanding of the environment more broadly, including other services that might be available for a client, creative thinking and problem solving, and this idea that refraining entirely from legal intervention might be the best approach. But there are limits and critiques to this model. First of all, it might not be appropriate when working with clients or communities who do not separate self from environment in this way. And a model is only so good as what you do with it. So how does this actually impact the law itself, I think, is an open question. I've seen a lot of application of this theory that doesn't focus on the relationships between the actors and the institutions. So it's used kind of to name, but not understand relationships between, and it doesn't talk about power. So what specifically are the relationships of power and domination that impact people's lives and limit their choices, which is why I really feel strongly that this structural violence analysis can help kind of situate this piece a little bit better. I love this definition. It's a bit dated 1998, although that seems to me like it was yesterday. But in expanding our definition to include structural forms of violence, we can better understand that social and government policies that valorize particular family forms and jeopardize others, programs that resolve local and national budgetary problems by withdrawing social support from the, quote, undeserving, unquote, many, and renewed emphasis on incarceration and other disciplinary techniques, very Foucauldian, produce violence in the guise of social stability and order. The net result of these and other practices is to engender a kind of structural violence that is normalized, and that's very important because we often don't see it operating around us. It's accepted as part of the status quo, but it's experienced as injustice and brutality at particular intersections of race, ethnicity, class, nationality, gender, and age. So I've taken a bold stab at what might be violence and trauma-informed approach. It draws on aspects of all of these, and then I'll end after this and invite your comments or your questions. So we could think about understanding structural and interpersonal experiences of trauma and violence and their impacts through practices such as deep, non-judgmental listening and critical self-reflection. Creating emotionally, culturally, and physically safe or safer, because I sometimes wonder if this word safe is possible, spaces for service users and providers that do not reproduce violence, foster opportunity for trusting relationships through choice, collaboration, and connection, including the option not to engage, focus on a client's and community's capacities and strengths, recentering advocacy to both individual harms, but also the systems that perpetuate harm, including in the way systems interact with one another. Consistently interrogating unacknowledged biases and unacknowledged systems of power. There's this fantastic quote I read last night. There is a fate worse than that of being a trauma victim, namely that of not even being recognized as such, which is the experience of so many women who've experienced sexual violence. Ensure the advocates themselves can be supported, work in interdisciplinary, non-hierarchical systems to the extent possible, listen to and actively solicit community feedback, and evaluate and fund legal service provision in ways that recognize service providers' experiences and the experiences of clients. So thank you so much. I'm happy to talk with any of you about this. Here are my 2 email addresses. You can connect with me there, or I'm happy to talk with you afterward, of course. And I just loved this sign from the Calls for Justice from the National Inquiry into Missing and Murdered Indigenous Women and Girls, which I think really does reflect this kind of an ecological perspective as well as a structural violence perspective. And I'll leave up some of the kind of sites that I use. This isn't obviously all of them, but it was the most that I could fit on the slide without hurting your eyes. So you can take a look at that, but I can send you a fuller bibliography if that's of interest to you. Thank you so much for coming.
Thank you so much, Professor Smyth. That was very thought-provoking. We have time for a couple of questions. I invite you to go to the mic and you can introduce yourself and feel free to pose a question. I'll pose a question. Is there any application that you can see for this, I think, really innovative approach you've put forward in bringing structural violence into a systems theory approach? Are there any examples of that being approached in practice that you've observed?
Mm-hmm. Okay, so I'll give 2 examples. One is, of course, there are lots of clinicians and Indigenous communities where this is happening all the time. And I also wanted to highlight, it doesn't entirely capture this perspective, but to me, I have a bit of hope, is the recent decision, encampment decision in Waterloo, which is a mid-sized city in Ontario, where Justice Valente talked, I thought, quite meaningfully about the lack of availability of housing, and specifically places for people who experience homelessness to go, and the connection to encampments. So ultimately, we know that because of lack of government resources and policy, which he outlines in his decision very carefully, and I thought quite eloquently, it talks about the lack of services for people who are experiencing homelessness and find themselves then in encampments. And he does a really meaningful analysis of the value of encampment for people who are experiencing homelessness, the sense of community, the harm reduction. If people are using substances, they can do so more safely. And he digs into this from a interdisciplinary, I think, perspective, takes evidence from really useful sources, and ultimately does not grant the injunction to disband this encampment. He leaves open the possibility to doing so if the state or the city is providing spaces and meaningful opportunities for people to be housed in, not only housed, but housed in culturally appropriate spaces. So I thought that decision, he draws on other really meaningful decisions from BC and other jurisdictions, but that's just a recent example, I think, of a judge who's engaging meaningfully in at least some aspects of this approach. Thanks for the question. And you don't have to feel, I know this is a huge topic and it's a bit stressful, so I also understand if you're not in the mood for, Sarah, yeah, or Professor Buehler.
Thank you so much, Gemma. Is this on?
Yeah, I can hear you.
I'm actually asking a question on behalf of Professor Anna Lund. She's watching
Oh my
on
gosh,
Zoom.
hi Anna.
And we're just in text contact. She's in Edmonton. And she says, if there's time, I'd love to ask Gemma about how we could incorporate an ecological view of trauma into lecture-based courses in law school, which I think is a beautiful question.
Oh my gosh. Okay, I don't know if there are any educators in the room, but there is a whole pedagogy of trauma-informed approaches to pedagogy. I try to use some of them in my classes, but I don't know the extent to which I succeed. I've done a lot of research and thinking about this. So while talking about the topic, I try to also model the approach with students. Whether it's successful or not, I don't know. But okay, I think that the clinic requires this model because you are, again, like I was talking about at the beginning, not situating the problem only according to law, although it's always very important, and of course it's always an operation. But when a client comes to you and frames their issue, not as a legal test, obviously, but as a kind of messy, non-chronological, sometimes chaotic set of extremely challenging circumstances, you have to take, I think, a violence-informed, trauma-informed view, and it has to be situated within an ecological model. I'm not sure we also always articulate it that way in the clinic world, but I do think, just in observing this work over the past 16 years or 17 years, I guess, I've seen clinicians and lawyers do this. So we do these case rounds. So, you have students working with clients. They come together sometimes individually and sometimes in a group to discuss and learn from one another about the various cases that they're taking on. And in that discussion, it often is about all sorts of things beyond the law, although, again, the law is extremely important. So I think it does operate perhaps a bit chaotically and perhaps without it being acknowledged, but I think it does happen and is required to happen in a clinic context. I think it can be reproduced in simulations, and I think, in fact, it can be reproduced through discussion and through, profs or lawyers or principals or supervisors in firms having that knowledge and sharing it and framing their cases in this way. I think I'm just really articulating some aspects of what lots of people are already doing. But thanks for the question, and I hope you're well.
I'm in your class. You do a great job.
Oh my gosh. Thank you. Thanks, Peyton.
Well, on behalf of the College of Law, thank you very much for a very stimulating talk. We really appreciate it, Gemma, and all the best.
Thanks so much.